majority of us have overruled the judgment in E.V. Chinnaiah, we have held that subclassification of the scheduled caste for the purposes of reservation is permissible. Scheduled castes notified by the President under Article 341 are a heterogeneous class where groups within the class suffer from varying degrees of social backwardness. The struggles that the class faces do not disappear with the representation in the lower grades. The endeavor is to ensure true and effective representation of the socially backward classes across posts.
The Supreme Court has given the green light to a landmark decision allowing states to subclassify reserved category groups such as scheduled caste and scheduled tribes for the purpose of reservations. The 7-judge bench ruled that states can now subclassify SCs within the 15% reservation quota to provide better support for most disadvantaged groups. The Chief Justice of India emphasized the difference between subclassification and subcategorization, cautioning against using these classifications for political appeasement rather than genuine upliftment. The court noted that subclassification should be based on empirical data and historical evidence of systematic discrimination rather than arbitrary or political reasons. States must base their subclassification on empirical evidence to ensure fairness and effectiveness. Also, the court clarified 100% reservation for any subclass is not permissible. The debate on subclassification has been ongoing for years. It was initially former President Gyani Zail Singh who, as the Chief Minister of Punjab, set the ball rolling by reserving 50% of government jobs for Valmiki and Mahabhi Sikhs within the 25% quota through an executive order. Later in 2000, Andhra Pradesh attempted to subclassify the SC population through an act passed by the Assembly, but the statute was struck down by the Supreme Court in 2004. In 2010, a division bench of the Punjab and Haryana High Court struck down the provision for subclassification, relying on the E.V. Chinnaiah judgment. However, the recent Supreme Court decision overturns this, granting state governments the authority. Additionally, the court also opened the door for the identification and exclusion of creamy layer within these categories for the benefit of affirmative action. The court acknowledged that systematic discrimination prevents some members of SCs and STs from advancing. And therefore, subclassification under Article 14 of the Constitution can help address these disparities. This approach allows states to tailor reservation policies to more effectively support the most disadvantaged within these groups.